Well, it is one small step for law, one giant leap for Project Veritas, and those are my two nephews in from out of town.
I haven't seen them in over a year.
Kids, you're probably going to want to go in the house and play some Nintendo. This is going to be a very boring half hour. Take those hats off, too.
This is Montreal land.
Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie, and those were two of my, I think I have 15 nieces and nephews who have gone into the house to play Contra. And when I start by saying that this is one small step for law, but one giant leap for Project Veritas, we are living in a world now where merely being allowed to pursue your litigation is itself a victory. For those of you who don't know, that must mean that this is the first vlog you are watching, but I have been following the Project Veritas defamation lawsuit against the New York Times for quite some time, from the initial filing, to the New York Times motion to dismiss, to the judgment on that, to the motion for stay of the proceedings, and there's an update in that lawsuit. The New York Times motion to stay the proceedings pending the appeal of the dismissal of their motion to dismiss was itself dismissed. That means that Project Veritas can proceed with depositions, but let's just read through this judgment. Supreme Court of the State of New York, County of Westchester, Compliance Part. Project Veritas plaintiff against the New York Times Company, Maggie Astor, Tiffany Shue, and John Doe's 1 through 5 defendants. Now, I am not going to provide a detailed summary of the state of the file. If you have been around this channel for long enough, you basically already know what's going on, and in any event, the intro paragraph of this order does a good job summarizing the state of the file. Suffice only to say that this lawsuit is based on the New York State anti-SLAPP legislation, which was recently amended. And for those of you who may not know what SLAPP legislation is, it is strategic lawsuits against public participation, and it is the idea that some people file lawsuits knowing they have deeper pockets than their defendant, knowing that they're going to lose the lawsuit, but they file it in order to silence the defendant, and so certain states have enacted certain legislation to preemptively, sort of prematurely put an end to abusive lawsuits. And that is the argument that the New York Times raised in order to dismiss this lawsuit. They basically said that Project Veritas filed a SLAPP lawsuit against the New York Times. The New York Times lost on that motion, and in the interim, while they appealed that motion, they asked for a stay of the proceedings so that Project Veritas could not depose the New York Times pending the appeal of the dismissal of the motion to dismiss the lawsuit. Suffice to read the footnote number 1 of the court order. New York's anti-SLAPP, quote, strategic lawsuit against public participation, end quote, statute is codified at New York Civil Rules 70A. The legislative history of the statute defines its purpose as providing, quote, the utmost protection for the free exercise of speech, petition, and association rights, particularly where such rights are exercised in a public forum with respect to issues of public concern, end quote. The legislature noted that the statute was enacted to protect against threat of personal damages and litigation costs, which can be and have been used as a means of harassing, intimidating, or punishing individuals and others who have involved themselves in public affairs. That is the essence of New York's anti-SLAPP statutes, and that's pretty much the essence of anti-SLAPP statutes across the country, and the intro paragraph to this court order does a good job summarizing the lawsuit, and I'm just going to read it directly so that the YouTube overlords cannot accuse me of saying something that I'm not allowed to say on YouTube. This is an action for defamation against the New York Times and two of its reporters, Maggie Astor and Tiffany Shue, for their reporting on a video published by Project Veritas on September 27, 2020, attacking mail-in voting in Minnesota and purporting to prove that United States Representative Ilhan Omar, quote, Rep. Omar, end quote, and or her campaign were connected to or involved in an illegal voter fraud scheme. On September 29, 2020, the Times published a story by Ms. Astor referring to plaintiff's journalism as a, quote, coordinated disinformation campaign, end quote. The story labeled the video report, quote, deceptive, end quote, made claims of voter fraud, quote, through unidentified sources with no verifiable evidence, end quote, and accused plaintiff of, quote, making claims without evidence of ballot harvesting, end quote. Despite plaintiff's demands that the alleged false accusations be retracted by the Times then published online stories by Ms. Shue in October 2020, which similarly claimed that plaintiff's video report was an example of, quote, false voter fraud stories, end quote, called it, quote, deceptive, end quote, and stated that the report made accusations of unlawful voting practices, quote, without named sources or verifiable evidence, end quote. Let's see if I can get this all in one breath. Project Veritas then sued the New York Times, Maggie Astor, Tiffany Shue, and 5 John Does for defamation. The New York Times and the other defendants sought the dismissal of the lawsuit on the basis of anti-SLAPP legislation. Their motion to dismiss the lawsuit was itself dismissed, and they appealed the dismissal of their motion to dismiss and sought the stay of the proceedings pending the hearing on their appeal of the dismissal of their motion to appeal. I can't believe I did it. Defendants now seek a stay of discovery pending the hearing and determination of their appeal of the court's denial of defendants' motion to dismiss the action. In sum, defendants argue that 1. A stay is necessary to avoid prejudice to defendants and ensure meaningful appellate review. 2. Staying discovery during the pendency of the appeal will not prejudice plaintiff. 3. Denial of a stay would result in the waste of judicial resources and needlessly burden all parties. And 4. The appeal has merit and raises novel legal questions of first impression. An element of irony here that many people might have already picked up on is that the New York Times is arguing that they need a stay of the proceedings, a stay of depositions, so that they will not needlessly waste judicial resources. So what do? They file an appeal requesting a stay of the proceedings, thus wasting judicial resources. For the proceedings and the briefing on this motion to stay the deposition, they probably could have held some of the deposition already for the same cost. Regardless, those are the arguments that the New York Times raised, and the court is just going to systematically reject each and every one of those arguments. Defendants argue that while New York courts have yet to pass on this precise issue, courts in states with similar anti-SLAPP statutes have repeatedly held that discovery should be stayed pending the outcome of an appeal of the denial of an anti-SLAPP motion to dismiss. All have pointed to the fact that allowing discovery to proceed during the pendency of such an appeal would undermine the very relief sought, namely the ability to avoid the burden of discovery and litigation. The judge then goes on to address Project Veritas's arguments against the New York Times request to stay the discovery pending the appeal, and essentially Project Veritas is rightly arguing that justice delayed is justice denied. There's absolutely no reason to stay the discovery pending the appeal, and that any such stay could last upwards of several years. Finally, plaintiff argues that it will be severely prejudiced by a stay. Plaintiff first argues that a complete stay of an action is inherently prejudicial to the plaintiff. Plaintiff submits that New York courts recognize that, quote, justice delayed is justice denied, end quote, and that therefore, quote, some excellent reason would have to be demonstrated before a judge is asked to bring to a halt a litigant's quest for a day in court, end quote. It is precisely because of the, quote, significant prejudice, end quote, resulting from a lengthy stay that the New York courts have considered a full stay of litigation to be a, quote, drastic, end quote, remedy that requires extraordinary justification. Project Veritas argues that not only would the delay be lengthy, potentially upwards of several years, but that it would further embolden the New York Times to continue to publish allegedly false and defamatory information as relates to Project Veritas,
as the New York Times has continued to do.
After summarizing the respective positions of the parties in a manner that I would qualify as bona fide steelmanning of those positions, the judge goes on to explain why the New York Times is not entitled to a stay of discovery pending their appeal. CPLR, which stands for Civil Practice Law and Rules, section 5519C, provides that, quote, the court from or to which an appeal is taken may stay all proceedings to enforce the order appealed from pending an appeal, end quote. Similarly, CPLR section 2201 provides that, quote, except where otherwise prescribed by law, the court in which an action is pending may grant a stay of proceedings in a proper case upon such terms as may be just, end quote. Upon both provisions, courts have, quote, broad discretion to grant a stay, end quote, of discovery in actions pending the resolution of an appeal. The judge then, rightly in my mind, goes out to explain that a stay will be granted when not granting a stay would effectively moot the question at law or create a situation that cannot be undone by a final judgment on the appeal. The court next turns to the defendant's argument that meaningful appellate review would be impossible without a stay because defendants will effectively be prevented from receiving the full relief they seek on appeal, i.e. dismissal without the substantial cost and burden of discovery. It is well settled in the law that a stay is appropriate when, without a stay, the relief sought on appeal will be mooted. And the judge cites a decision in which a stay was granted, granting, quote, stay pending appeal pursuant to CPLR 5519C, end quote, because, quote, unless a stay is granted, the appeal will be rendered moot by virtue of the fact that defendant will be forced to file the financial disclosure statement prior to the appeal of whether the financial statement disclosure statement is required being determined. All right, so that might be a little confusing because I think there's an extra word in there somewhere, but more simply put, the judge is saying that the court may grant a stay when, if they do not grant a stay, the question at issue itself will be resolved and will not be able to be undone even if the appeal is granted. In the decision the judge is referencing, the question at issue was whether or not a party had to communicate a document. So if a stay was not granted and the party was ordered to communicate that document, well then, even if they succeeded on the appeal, it would have become moot by virtue of the fact that they would have already communicated that document. And in this case, the New York Times is not saying stay the appeal because we don't want to be subjected to discovery. They are saying stay the appeal because we think we're going to succeed on the merits, and all that they're going to stand to lose, even if there is no stay of the discovery, are the costs of the discovery. Even more simply put, nothing can be done that cannot be undone if the New York Times ultimately succeeds on the appeal of the dismissal of their motion to dismiss, because if they succeed on the appeal, the lawsuit will be dismissed and all they will have incurred were the costs of discovery. And perhaps more importantly than that, the judge astutely observes that the New York Times has failed to produce one authority justifying the stay of discovery in virtue of a dismissal under an anti-SLAPP motion to dismiss. The court next turns to plaintiff's argument that the the denial of an anti-SLAPP motion to dismiss is no different than the denial of a motion to dismiss in other areas of litigation, because under the anti-SLAPP law and CPLR section 5519, defendants are not entitled to an automatic stay pending appeal. The court agrees. The history and text of the anti-SLAPP law demonstrates that the legislature did not intend to deviate from the general rule that no stay is available pending appeal of a denied motion to dismiss. Although defendants describe the anti-SLAPP law as a, quote, newly enacted statute, end quote, the primary recent amendment to the law merely enlarged the class of defendants who may take advantage of the motion to dismiss and burden-shifting procedures. Despite the fact that New York defendants have been permitted to file anti-SLAPP motions to dismiss for decades, the defendants here failed to cite any cases in which an unsuccessful movement was granted a stay pending appeal of the denial of an anti-SLAPP motion to dismiss.
Oh, snap.
That is pretty much as big of a judicial smackdown as anyone can get in the court of law. You basically have the judge telling the New York Times you have no authority to support your position, and authority, for those who do not know, means jurisprudence, case law, something to defend the position you are taking before the judge. And then on the issue of justice delayed is justice denied, a little more of the same, but I like the way the judge says it. Plaintiff will be substantially prejudiced by a stay. In deciding whether to stay a case, the court considers prejudice to the opposing party. Here, a delay of up to 3 years is likely if a stay is granted. As argued by plaintiff, New York courts recognize that, quote, justice delay is justice denied, end quote, and that therefore, quote, some excellent reason would have to be demonstrated before a judge is asked to bring to a halt a litigant's quest for a day in court, end quote. Far from considering a stay to be merely some harmless pause, it is precisely because of the, quote, significant prejudice, end quote, resulting from a lengthy stay that the New York courts consider a full stay of litigation to be a, quote, drastic, end quote, remedy that requires extraordinary justification. Here, having first failed to convince the court that plaintiff's case should be dismissed, defendants also failed to demonstrate the extraordinary justification required for the imposition of the drastic remedy of a stay pending appeal. Accordingly, it is ordered that defendant's motion is denied without prejudice to defendants seeking a stay from the appellate division. From what I understand of this section of the order, there is still something of an outside chance that the New York Times could ask the appellate division to stay the proceedings, although from what I have been told, it is extremely unlikely that the appellate division would ever issue such a stay given this particular order. But what I love about this judgment, it's not just the question of justice delayed being justice denied. It was when the New York Times actually argued in their argument brief that there will be no prejudice in the delay, in that witnesses are not going to disappear, emails are not going to get deleted, and when I read that as exactly the opposite. Witnesses will disappear within the next few years, emails will get deleted within the next few years, and so justice delayed, not only justice denied, it is going to be evidence destroyed. And a full disclaimer here, I am not raising that as an accusation of fact, I am merely raising that as a possible risk of things that can happen if there is a 3-year delay in discovery. Accidents happen, servers crash, emails get deleted, witnesses go missing. You never know what happens when you are forced to wait years in order to depose someone. So when the New York Times actually raised this as an argument against any purported potential prejudice that Project Veritas would suffer if there were delays in deposition, I read this as the exact opposite, almost as a prediction of what the New York Times might actually do. And that is the judgment, a massive victory for Project Veritas in that they actually get to proceed to deposition, and what a day, what a state of law it is when your massive victories consist only of your ability, your right to be able to depose your defendant. Something tells me we are not yet done with the dirty games. The story does not end here, but at the very least for the time being, this is really going very well for Project Veritas.
And I cannot wait to see those depositions.
And with that said, if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
Tina, you fat lard, come get some dinner.
If you want to support the channel, all of the support links are in the pinned comment. Robert Barnes and I do weekly live streams every Sunday. We do weekly streams with a guest every Wednesday called The Sidebar. If you want to find us and support us on Locals, you can find us at
VivaBarnesLaw.locals.com.
All of my content is also on Rumble, so you can follow me there, but more important than anything, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah!